Hi there, Daryl Tuttle here. This video is about retirement account trust. Now, a trust is a legal construct that is very important in asset protection law and estate planning. And we talk about trust quite a bit, just in general. But the problem that we're trying to solve is simply this. If you contribute to a retirement account and it grows to like have a large account balance, but only take required minimum distributions out through your retirement, then you're mathematically guaranteed, assuming a reasonable rate of return. Like we just finished a bull market, and so now we're looking for lower returns than we have maybe in the last 12 years. However, even with a modest rate of return, if you only take RMDs, required minimum distributions from your retirement plan, you are mathematically guaranteed to have a large account balance left over at the end of your life. And so how does that significant asset, retirement account, it's like a tax-deferred gift from the government that can go on for generations if we plan it correctly. However, in most cases, in order to avoid unnecessary estate tax, we have to use a trust. Another reason to watch this video is even if you live in a state, remember there are 12 states that we go over in the video that have separate death taxes. However, even if you have an estate that you do not believe will be taxable, do you have concern about your surviving spouse if you're married and Medicaid liens, spend down, high unreimbursed medical expenses related to long-term care? If so, it's advisable, and in some cases the only way to avoid these Medicaid lien spend down periods is to use a special kind of trust created under federal law. I call it a 42 U.S.C. trust, or to spark that mental image, a spousal protection trust. Then your retirement account needs to point to those type of trusts, either a credit shelter trust for estate tax purposes, which we discussed in this video, or a spousal protection trust, or a combination of the two to avoid unnecessary asset erosion, estate erosion for the surviving spouse. Ultimately, our goal is to come up with an asset protection plan that renders your estate, your assets, your property unreachable by creditors during your lifetime and through the life of your spouse, and then passes on to children, and so that they don't blow it at the Audi dealership, as I often say, but rather have a financial plan that could go, like, think about the long game. Think about the third generation. We do not have enough wealth to lose it to income tax, unnecessary income taxation, especially death taxes, or these high unnecessary, inflated, absurdly expensive long-term care costs. So that's what the video is about. You can, the other thing I wanted to say is the format for the video is office hours. So the BoomX Academy is a project that I've started in which we have live Q&A and presentations weekly. And so you will see that I am presenting during office hours. The last part of the video is just the questions that the people from office hours asked. And you likely had the same questions. And they ask about retirement accounts, they ask about the presentation, but they also ask about, like, trusts in general. What is a trust? Is it something that I put money into as I go along? Do I have control? Is it flexible? I answer those questions and more. So hope you enjoy the video. If you do like it, give it the thumbs up and subscribe. That would be awesome. If not, I hope it is of value for you. The place to start is with this illustration. And really, if you think about it, what is it that Americans do? I think that they work, they save, they accumulate wealth, and then they die. Okay, now that's a little bleak. Shannon's young, so, she's like, oh, really? That's what I have to look forward to? I work, I save, then I die. But, from an estate planning perspective, we're really like trying to fast forward to that last moment of life and asking a simple question, and that is, what do we do with the assets that were left behind by the asset owner? Like, title has to be clear. America is obsessed with title and real estate in particular, but also all financial accounts. Remember that there are two broad categories, rather, of assets property rather in America. One is real property, which is real estate and property interests, legal interests that attach to real estate. The second is personal property. Personal property has two categories. One, tangible personal property. It's not something that you can touch. Intangible is, like, if you think about intangible personal property, when the Roman Empire was around, there was no intangible personal property. But today, a lot of property is intangible. And intangible is something that has value that is not physically present in the world. For example, intellectual property, if you have a patent or if you have a right for royalties, all that, it's like you can't reach out and grab a royalty. You can't reach out and grab even your financial account. Like, most of the wealth that we have as Americans today is digits on a computer screen, right? That's intangible personal property. And the law has different rules for the way it transfers at death compared to real estate. Real estate and real property always has always and will continue, as far as I know, forever, by deed, by a deed. Now, a deed is a written document that's signed by the grantor and the grantee, the person that owns the property, and the person who is transferring the property or receiving the property, either through a sale or through inheritance. Like, at inheritance, mom and dad own the property, they're both dead, and now the kids own it. Well, you've got to record a deed that makes that transfer. So title insurance, in particular, title insurance can look at the deed and say, okay, mom and dad died, a court adjudicated it, decided they died, and it's a lawful transfer. And now we're just going to record a new deed. I used to be intimidated by deeds: statutory warranty deed, quitclaim deed, personal representative deed, transfer on death deed, all these different types of deeds. Now I totally dig it, because a deed is just a piece of paper that you record with the county auditor, the same organization that we trust and have confidence in to record and transfer real estate, is the same organization that one political party believes is not even competent enough to handle an election. That aside, we have great faith in, like, the auditor's ability to keep track of public records. And transfer of real estate occurs by deed, right? Now, if you think about, like, a retirement account, well, what is a retirement account? I mean, almost always a retirement account will transfer at death. Like, you don't need a retirement account anymore when you're dead. I mean, just like concede logically that your retirement's over at that point. And so how does that work? And I will remind you, if you only take out required minimum distributions from your retirement account beginning at age 72 under the new Secure Act, well, and you have a reasonable rate of return, you're mathematically guaranteed to have an account balance left over at the end of your life. From my perspective, there's large amounts of money being passed from my client's generation to subsequent generation in the form of retirement accounts, like an unbelievable wealth, right? Now, to me, it just seems reckless and irresponsible that the retirement accounts just kind of transfer automatically because somebody filled out a beneficiary designation form at the custodian. There are currently 12 states, Washington State being one of them, that also has an estate tax. Now, when we're talking about retirement account planning, we're only thinking of income taxation, because what happens is you work, whatever you make, you pay income tax on that income. However, you're entitled to deductions from your total income to establish taxable income. One of the deductions is the amount that you contribute to your retirement account each year. So if you make $100K and you contribute $6,000 to your IRA, your taxable income is not $100K, it's $94,000 taxable income. Now, what's amazing about retirement accounts is that when they grow, I mean, we're just finishing up the longest bull market in American history. I mean, I can't even believe it's gone on this long. It's like, I think the longest bull market in American history before that was like 8 or 9 years. And for the last 2 or 3 years, all the experts have been saying, when is there going to be adjustment? Well, we're going through that now, but there's been just like amazing growth in retirement accounts in the last 12 years. All of that growth is tax deferred. And so if you own the same mutual fund in your IRA account as you did in a brokerage account that was not a retirement account, you would not have the same amount of money after 12 years, because every single year, the mutual fund company issues a 1099 and you're paying tax on the gain inside the mutual fund. So it's like eroding your return year after year after year. I mean, we all understand the concept of compounded interest. Well, it matters. And so these retirement accounts grow to be very, very large. Now, the problem is in these 12 states, Washington being one of them, there's an estate tax. And estate tax is overlooked. It's probably the most underappreciated death tax or tax in American jurisprudence. The problem with estate tax is it's brutal, man. It's like a flat, in Washington state, it can be as high as 20%. Other states, I mean, I'm like Oregon has 16%. I'll show you the list here and we can kind of go through it. But just imagine you wake up one day, the stock market has fallen 20%. Like from January 2022 to July, it's like slowly, the market has slowly declined to 20%. Imagine if that happened overnight in an instant. It would be astounding. Yet when your heart stops beating, if you're not mindful of estate tax, what you worked for your entire life and what's left over for you to pass on is 20% less than it was the day before. Now, there's one thing that we can do that's very, very easy to help reduce, sometimes eliminate completely this estate tax, sometimes mitigate or reduce the amount owed. And that is this concept of a credit. Now, in all of the states, these 12 states, we're not worried about federal estate tax. Federal estate tax, let's just pretend it doesn't exist. Let's just say we live in one of these 12 states. There's the 15 or up to 20% tax. And there's this thing called a credit. Now, a credit means it is the amount of your estate at the moment you pass away that's tax-free. So the state government says, look, we're not total greedy guys. We want to give you some break. And so every state says, okay, the first X amount of dollars, don't even worry about it. If you pass away and your state is below this credit amount, you don't even have to file a tax return, which is nice. Like, who wants to file a tax return if they don't have to? In Washington state, it's $2 million. In Oregon, it's $1 million. We'll go through the list here in a minute and look at other states. But $2 million, I mean, like, there's a lot of Americans that do not have $2 million. Now, if you're on this call, I just happen to be familiar with you, and I can say that you are already there, or you will be at that level. So you are already a taxable estate, or you would not be listening to this. Now, when the first spouse dies, if the first spouse makes the mistake of using a Susie Orman or Dave Ramsey estate plan that promises to protect your assets, what will happen is when the first spouse dies, everything is going to go to the second spouse. That's what will happen. Now, there's an unlimited marital deduction, but unfortunately, the estate did not properly capture and elect the credit. So, like, this is not estate planning 101, it's tax planning 101, but like, just remember, if you live in one of these 12 states, what you have to do is capture that credit. Do not let it go. And there's a thing called a credit shelter trust. Rather than giving this surviving spouse all of your estate outright, rather ask this question, is the estate taxable? If it is, then transfer an amount of the estate of the dead spouse into a special kind of trust that will hold the money for the benefit of the surviving spouse, but does not count as the surviving spouse's assets at her death, his or her death. If you do that, you will increase the tax-free part of the marital community from just one credit to two. So in Washington, if it's a $4 million estate and you failed to properly capture your credit, then and if you look at this flow chart, it's asking a basic question: is the estate taxable? Yes or no. If it's not taxable, or you don't even know what a credit is, and you use a simple transfer, then the surviving husband in this case is going to receive his dead wife's estate, which means that what he owns at the end of his life is $4 million. Well, that's unfortunate, because everything over $2 million will be taxed. $4 million is about a 16% tax. So the government is going to have a check written by the personal representative for $160,000 in that case. I want to repeat that. In that example, the tax is going to be about $160,000. Now, for just a little bit in attorney's fees, what could have happened is, like, look, let's just transfer $2 million of the dead spouse's estate into a credit shelter trust. When the second spouse dies, no problem. Second spouse only owes $2 million. The trust only owns $2 million. That's below the credit. Neither the second spouse to die or the estate has to file a tax return. You just avoided $160,000 in estate tax. Now, that's pretty easy, right? I mean, like, that part of it's not very complicated, I don't think. However, let's add just one more complexity to it. See if I can pull this one off. What if you also want to avoid Medicaid liens? Okay, so now we're like, oh, okay, here we are. We've got this desire to avoid estate tax. Is there a way to also avoid Medicaid liens, create a trust where look-back period, 5-year transfer, all these things does not matter? Well, you all know what the answer is, and the answer is yes. 42 U.S.C. allows you to transfer money into a trust. So this question is asking, how will it flow? Flow chart. Do you wish to protect assets from the chance of spend down, transfer penalties, or Medicaid liens? Well, the answer to that question is always yes. Like, if you're a rational person, what rational person wants to subject their surviving spouse to Medicaid liens, transfer penalties, and look-back periods? It's not like logically it's always yes. People just don't know. Also remember that retirement accounts have this rule, and it's called the non-natural person rule. Non-natural person. And that rule is a pain. What it says is, look, ERISA statute and the income tax statute, we're going to give tax deferral to y'all, but it's only for the worker. That's the goal, to save for retirement. And so it's always been, you have to have one retirement account and one person as the owner / beneficiary. A person. Well, when the owner dies, now we've got a problem, don't we? Because sometimes in estate planning, we want to give to a trust. Well, ERISA and income tax is like, what? No, back up. Income tax, we don't care about estate tax. What are you talking about? It's almost like the government's incompetent. It's like they make a law over here and they don't know what they made over here, and it gets confusing. Finally, the law said, okay, look, you can leave money to a trust and not blow up your retirement account, the rules, the trust is irrevocable and it has one identifiable beneficiary, there's no control, like beneficiary can't control things, and a few other requirements that are too technical and beyond the scope of this presentation that really don't matter. But the simple part of it is there's an exception. Retirement accounts must point to a beneficiary or a very, very specific kind of trust. Now, the conflict is retirement accounts are intangible personal property. Credit shelter trusts and 42 USC spousal protection trusts can hold anything. It can hold real estate, it can hold personal property, and it can hold intangible personal property. I'm going to repeat that. One of the things you always have to remember is retirement accounts are very specific. Like it can hold, it's like digital assets, and it only transfers by a beneficiary designation form with a plan administrator. That's it. Spousal protection trust and credit shelter trust can hold anything. Those assets transfer by deed, real estate does, or by assignment, or sometimes by contract. A lot of times, or you could just open a probate and the personal representative can reach out and grab the asset and bring it in. It's pretty amazing. But those transfer rules are different. Real estate transfer rules date back to the Middle Ages. Retirement account rules for transfer go back 40 years. Like that's it. Now we do have this like little exception. And one thing that's hard to understand about retirement account trust is that, okay, look, if I have a $4 million retirement account and that's all I own, and I live in Washington, oh no, we're going to lose 20% of this retirement account at the second death. Like, think about that. I mean, like, we're going to lose hundreds of thousands of dollars from our retirement account because at the second death, the only thing that we owned was a retirement account and it's above the credit. And so the problem for planners was, okay, like how do we avoid estate tax when the major asset is a retirement account and we're limited in the way that we can transfer property to a beneficiary designation form? If you name a retirement account, if you name your estate as the beneficiary of a retirement account, when you pass away, the IRS is going to say, that's not a person. That doesn't meet the exception. There's one narrow exception. Naming the estate is not the exception. And therefore, it's income to the estate. And we're going to impose the highest tax, well, whatever tax bracket you're in. But if it's a large retirement account, it's going to pay out as income. And there's going to be a 35% loss. And on top of it, if you're over the estate tax limit, credit amount, you're going to pay a 20% tax. I mean, like, it's possible if you blow this rule, you're going to pay a 55% tax. Like, is that why you worked at Boeing? To lose 55% when you pass away? Now, what we can do is we can create a separate kind of trust. I just call it a retirement account trust because I want to spark that mental image. I'm working on the name because I don't like the name retirement account trust, but it's just a trust that meets the requirements of the Internal Revenue Service. So when we point the IRA at death to the trust, it doesn't blow it up. It will not be counted as income to the estate. It will not be counted as income to the beneficiary. It's going to hold it for income tax purposes. Now, if it just happens miraculously because we got a big brain, we understand the rules, that's what you're thinking. I know you all, you're like thinking, okay, well, what about estate tax? Well, that's the right question to ask because we could also include in the trust all the rules that meet the estate tax credit exclusion. So we can combine the concepts. We can have a credit shelter trust that avoids death tax in those 12 states, or federal, but let's forget feds, state tax, and does not blow it up for income tax purposes. Now, the problem is when people get confused because they're like, okay, I've got my spousal protection trust and it's in my will, but you drafted for me a retirement account trust that seems to be mirroring the language in my will. Well, the problem is, don't yell at me, it's not my fault. A 42 USC trust must be created by a will. That's what the law says. But retirement accounts do not transfer through probate. They transfer through designation form. So we've got these two different ways to transfer property. And so what we have to do is just say, okay, look, I know we don't like complexity. We want it simple, but to fund a spousal protection trust, it has to be in a will, it has to be a probate. But to capture the credit with a retirement account trust, we have to use designation forms and it has to be standalone. They say the same thing. Like, we want to fully fund the credit, we want to capture it. And then when you look at the retirement account trust, guess what it says? We want to fully fund the credit, we want to capture it, but it's two different systems. Like, just think of it, probate assets, non-probate assets. That's the way it works. If you do it correctly, really wonderful things are going to happen. Number one, you're going to avoid a lot of tax. Number two, when the second spouse dies, you can just continue that little trust for 150 years. Like, that's the beauty of it. It's not just tax planning, it's family planning, because we avoided, remember, there's two deaths. You're going to pass it on to your spouse, but he or she's going to die eventually, rather than just roll it over the kids who blow it at the Audi dealership the day after they inherit it and then pay tax. It can go on with pension. It can go on for 150 years, whatever ways in which you can conceive to control your money from the grave, you can do with the retirement account trust. Now, that was 36 minutes, so I went over. I am now ready to answer questions. You got to unmute, Steve. Somebody tell Steve he's got to unmute. There you go.
Okay. Just following instructions.
Yeah.
So one of my biggest things was exactly what you said at the end. Here I've got two documents basically that say the same thing. And I was wondering, because nowhere in my will or my funding instructions or disposition of assets does it talk about a retirement account trust. So, and that's probably because the retirement account, like you said, transfers with beneficiary forms. The other trusts that transfer during probate. So I just, because I was wondering at time of probate, is it going to be any confusion with my trustee going into probate and say, well, we got a retirement account trust over here, and we got a spouse protection trust over here, and a credit shelter trust. So as long as the retirement account doesn't even enter into probate, that helps out.
Well, Washington State, we're trying to speak to the entire country. Washington, I think, is the only state that has a super will provision, which means that the executor, personal representative, has a legal authority to pull into a probate assets, even if the beneficiary designation contradicts the will, if the beneficiary designation form was updated or filled out before the will. Now, theoretically, a personal representative could reach out and grab a retirement account and dump it into a spousal protection trust. However, the teaching point is that would be a disaster, because it's going to be a lump sum distribution. At the end of December 31st, the plan administrator / custodian is going to issue a 1099. And you have to report that on the income tax. Well, it'll be an estate return, state tax return, or not like an estate return for income taxation, but and it will tax at the highest tax bracket. If it's a large account, over 30%. What is the brackets now? They change a little bit, 31, 35%. Plus, a 20% tax. That would be horrible. And so we really do have to, that's why retirement account trusts are hard, because what I like about, look, let's pick on Shannon. She's young, she's doing well, she's planning ahead. But we can set up a will for her. Well, for you all, actually, all of you are going to have the same will she's going to have when she's done through the process, but it's going to be flexible. Like, wills are nimble. They really are, because they're saying, look, we want this to happen if our spouse is old and decrepit, or we want this to happen if it's a taxable estate. The only thing that we can't do is micromanage a retirement account. They have to be channeled out, and it has to duplicate the tax saving strategy in the will. That's just one of the curses of being high net worth. Like my clients who say, this is getting complicated. I say to myself inside that I can't say because I'm a professional. I go, where your diamond slippers are too tight. Because you're like high net worth, That's a first world problem, Susan. We don't have those problems here in Puerto Rico.
Where do the RMDs get deposited from the retirement account trust?
Well, okay, so there's Conduit and Accumulation. If you want to, and the difference between it is what I decide as a drafting attorney based on my client's objectives. One version is Conduit, which means the RMDs just pass through the trust directly to the beneficiary. And that's fine. We can do that. Most of my clients are like, with Secure Act was enacted in 2019, December, effective in 2020, January. And it reduced life expectancy payout for the second generation to 10 years. Well, damn, there's not many of my clients that are happy about that. What they want to give the heirs fiscal responsibility and a 10-year payout. Can you imagine $100,000, $200,000 paying out every year to your kids? It's crazy. So instead, what they want is accumulation. Accumulation means I draft it in such a way that it pays out to the trust, not to the kids. So the trustee just reinvests it. That's the mojo. That's how you get family generational wealth to the third generation. Also, 42 USC trust, a spousal protection trust or a Medicaid trust, has to be an accumulation trust. Cannot be a conduit trust. And so if you ever hear somebody talking about conduit trust, raise your hand and say, well, what if the beneficiary is disabled? And if they don't know accumulation trust, then change the channel. Go listen to Dave Ramsey, because he knows what he's talking about. Shannon and I like Dave Ramsey. You know why? We look exactly the same.
He's the one that got me on my path, though. So he's my diving board. So I graduated from him. He's a good start.
Yeah, he's a good start. You know what I don't like about him? He's kind of mean.
He's very mean. I have a struggle listening to his podcast. I get uncomfortable in my own home. I'm cooking, I'm listening to a podcast, I'm by myself, and I start getting embarrassed for the people that he's talking to. So It's like, man, you must feel like super small by the time you're done dealing with that man.
Yeah. And I don't know. The thing that bothers me is, he talks a lot about his faith. And I'm like, was Jesus this mean?
So Daryl, and excuse my ignorance, with these trusts, is it like an a la carte deal where you can have, you're like, I want that trust and I want that trust and I want that trust. And you utilize them all for the things that you need, depending on what you have for assets for retirement planning. And you've got one doing conduit work for you, and you've got one doing other work for you. I mean, is this like a bunch of cogs in the wheel sort of thing?
Yeah, the law is hard because it's not linear. It's chaos. And so a good planner is reaching out and grabbing solutions from different areas of the law based on a fact pattern, right? And like most of what people, like living trusts are being marketed and sold for tens of thousands of dollars sometimes across the nation because they're easy. It's like, if you want to avoid probate and want to pass wealth to the next generation, you can buy this overpriced living trust. Even Susie Orman and Dave Ramsey sell them. They're not even lawyers. But when you understand the concept of asset protection as compared to estate transfer, then you have to be a la carte. Like you have to go out and grab a particular type of trust that's structured a particular way to solve your particular problem. Let me give you an example. If your estate's below 20 million and you do not live in one of those 12 states, you don't care about a credit shelter trust. Like, why would you? If your estate is, let's say your estate's 3 million and your third spouse's estate is 1 million. Well, you have to use a trust because I'm assuming you have different heirs. Like a third marriage, usually you have a set of kids from both marriages. And so what you want to do is you want to give a gift to your spouse because you love them, but for their retirement. But then at the end of their life, you want your estate to go to your kids, not her kids. Now, a credit shelter trust, you're really only using that for the credit amount, right? Up to 2 million. What about the extra million? Well, to do that, you need a different kind of trust called a QTIP, Qualified Terminable Interest Property Trust. And so we're funding the, what are you laughing at, Susan? I see what you're saying. What?
Because I just wonder if Shannon is thinking all the things I used to think when I was like, oh my God, another trust.
You see smoke coming out of my ears. I won't show you what I have written down on my paperwork here, Susan. About
No, I want to
trust.
see what is it? What is it?
Down on the very bottom, it says trust, heavy spending. That was from a couple of these ago.
In other words, blah, 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 trust, blah, 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 blah.
Daryl knows that all I want is a bunch of instructions on how to pick the right trust.
Oh my
Right.
God, you're
I
killing me.
am linear. I am a linear human. So this is a struggle for me.
Look, the thing is, I made that article. I published that article on funding instructions. You should have seen it before I worked on it. It was incomprehensible. But I believe we can do it. I believe that I believe it's not that hard. It's not that hard. And to answer your question, you have to grab a trust. Trusts are amazing. Like, it's such a great blessing in the law because a trust can do anything you want it to do. And if you think about the way people don't do it, but like with your money, you could have a plan for pots of money. Like, I'm going to create a separate account for vacations. I'm going to create an emergency fund account. You would invest those differently. Like, I'm going to create an account for my grandchildren's education. Well, for emergency account, it's cash. Like, you're not taking market risk on the emergency fund. But for your grandkids, man, why not buy Bitcoin? They're 5 years old. They got another 15 years. Like, let's be aggressive. Like, let's petition everything out. You can extend that to death. The problem is if you don't use a good trust that's drafted correctly, the beneficiaries are going to blow it. It's like they don't know what you know. They haven't been to office hours. They haven't thought about the stock market. They haven't thought about taxation. They don't know. And so a trust is your gift of all of your experience. If you accumulate everything that you need to know about the law and pass away without a trust, that hard drive is dead. Everything that you learned served no value. And it has to, and what's great about a legal document, like financial services has really done a disservice because they go out, they're a bunch of hacks. They have no training and they're just selling stuff. And the reason all of the transfer on death beneficiary forms have developed is because financial services wanted to control the money. Like they want to keep it in the custodial level. But there's like a legal document has to be followed. Like if you have a retirement account, Shannon, and you go to your Raymond James guy and say, hey, you know, blah, and he'll say, hey, I'll make you a retirement plan. All you have to do is invest with me. And then they come up with a spreadsheet that shows you what you're going to make every month and all this bullshit, all this stuff. Nobody has to follow that. And nobody does because you get it and you're like, okay, I bet you the average person spends no more than an hour on that document and they throw it in the corner. However, you put that into a financial power of attorney or a trust or a will, the person that has to execute that plan is held to the highest standard. Many financial advisors are not fiduciaries. A trustee is a fiduciary. They have to follow that plan to the letter. If they don't, it's super easy to sue them and get a judgment. So the power of the law is amazing. That's how you not only, like if you think about asset protection during your lifetime, Shannon, think about a power of attorney. That is a document that delegates decision-making authority when you had a stroke. When you're at the most vulnerable moment in your entire life, that's when the plan needs to be clear, it needs to be concise, and the person executing the plan needs to be held accountable. That's pretty amazing. But, people, oh, it's hard. I don't understand it. I get impatient with that part of it.
I got another question.
Wait, Shannon's talking, but I can't hear her.
Oh.
Did she mute again?
Mm-mm.
No, okay, what? Let's let Shannon speak.
Okay.
It's not coming through.
Her mic's not. She's going like this. I want to give Shannon some FaceTime because she's new.
Yeah.
Can you use the
That's
chat
weird.
feature? We have a chat. We never use the chat feature. What happened? She just lost. Okay, well, you get your technology squared away. Steve, what do you got?
Just a quick question. In the retirement account trust, it says that the retirement account trust is not funded until I pass. And, I know that there's a section that says, while I'm alive, my trustee shall regularly and conscientiously make appropriate distributions of the trust income. So am I in control of my retirement accounts before I die or not?
You are, yeah. A retirement account trust, well, I guess you could if you wanted to, but I don't see a reason to. Well, let me think about that.
It's just kind of conflicting
No,
information.
I don't think that you should. I can't think of a reason. Maybe there is one, but not one that makes sense to my clients anyway. During your lifetime, you just own it.
Right.
And then, it's just
pull out. Right. Yeah, that's
well, you
why
have to because it's funding your retirement.
Right. Yeah. And that's why I was
Right.
wondering, wait a minute.
You just have to change the beneficiary forms.
Yes, and so that's a hard part of a retirement. Well, it's one of the hard part of a retirement account trust because when I represent folks, like as the attorney, I also had to get on the phone with the custodian with my clients. Like I don't have to do that with, well, I guess I do sometimes, but retirement accounts, every single time you have to present the beneficiary designations to the custodian. And my beneficiary designations are like 5 pages long. Like they want their little form, who's the primary beneficiary? And they give you like 3 lines. You say like, whoa, look, dude, this is a high net worth case. Keep in mind, Susan, I just researched this. I'll have I'm going to do an article on it. But if you have $2 million, you're like in the top 2% of wealth owners in this country. 50% of Americans have net worth below $122,000.
Wow.
Yeah, no kidding. 1.9% of the population owns 40% of the wealth. And so like when you're dealing with financial advisors, they're not used to high net worth. They don't have a lot of high, I don't care who they are or what they say. And so, you got to get on the phone and say, okay, look, don't forget, I know you haven't been to law school and you have no training, but you're arrogant. But the truth is there's also estate tax, and so, and sometimes like you can't even do this with a 401k. You got to find a custodian, when you roll it to an IRA, people, whatever. Shannon, did you figure it out? Let's see if Shannon's.
I don't think so.
Yeah, I can hear you. I can hear you. No, you're good. What was your question?
I was wondering how do you get a trust? Do you purchase it? Is it something that you own? Is it something that you have to make a monthly payment to have set up for you?
No, a trust is a legal construct. So think about an LLC, limited liability company, or an S corp. You just draft articles of incorporation, you sign them, and you register with the estate, and boom, the law says, oh, there's an LLC now. So a trust agreement is a one-time thing, and it's a document. And once it's signed and funded, like you create a trust, transfer $10 into it, it exists, and then you can transfer wealth to it later. But it's like this legal entity that exists. And if we do it correctly, well, you have to like Washington State's changed rules on living trust, so you have to make modifications apparently. But the best kind of trust is one in which you do it one time, you create it, and it lasts for 150 years. That's the limit in Washington for a trust, 150 years. So you put a little bit of elbow grease into it, sign the document, and then you take the certificate of trust, which is a summary of it, to the bank, because the banks are dumb. They'll say, give me the trust agreement. No, Washington law respects my privacy. Here's a summary of the trust. Open the account. And then Bank of America goes, the Darrell Tuttle Living Trust or the Darrell Tuttle Credit Shelter Trust. And it's just like, what's the difference, Shannon, really? I go to the bank, I open a bank account. Who are you? Here's my social security number. My name's Darrell. Or go with the certificate of trust, call it the Darrell Tuttle Trust. They just put it into the computer and hit enter. Now it's a thing, right?
Mm-hmm.
And then you transfer money into it. Now, trusts are weird in the sense that they just kind of sit there and there's nobody micromanaging them. Right? There's nobody looking over your shoulder. However, if something goes wrong, or if you apply for Medicaid, or if you're audited for estate tax, like most Americans are not audited. Most estates are not audited. However, if you are, you pull out the trust agreement and you say, look, here it is. My dad signed it in 2017. It's a credit shelter trust. It meets all the requirements. And the tax guy says, oh, okay, yeah, you're right. You get the credit. Didn't mean to bother you. Now you could create like a living trust for a cabin in the woods. And you could say, look, we're not going to create an LLC about this because it doesn't have a business purpose. It has a family purpose, but we've got 4 kids in 4 different states and we have a cabin in Montana and we're going to put it in this trust. Here's the rules. Everybody's going to clean up after themselves. And when one of the 4 kids dies, it's going to go to the other 3 siblings, not to that deceased beneficiary's kids, because otherwise you're going to, 75 years from now, you're going to have 18 people owning a cabin that don't get along. See, you can like create a family trust that serves a family purpose that does anything. Like a trust gives your money power, gives your property something that means something. Okay, 7:30, that's it. That's 1 hour. You're done. Click.
Yay, I was about to say the
He's
same
been
thing.
blaming Puerto Rico.